I want to cut across to our other guests joining me, Dushyant Dave, Senior Advocate, Supreme Court, Aman Lekhi, Senior Advocate, Supreme Court, Swapnil Kothari, Senior Lawyer, Supreme Court. Swapnil Kothari, I think, you just heard Dr. Ashwini Kumar. We had the defense lawyer, former ASG before that. Why do you think this judgment, because you seem to believe that this judgment is a very fair judgment, what are your arguments?
Good evening. I firmly believe that this judgment is a fair one. You cannot treat what Gurmeet Singh did of Dera Sacha Sauda with what Sharjeel, Imam,
but we're not treating that, Mr.
Umar,
Kothari.
Khalid.
That's just, nobody's, okay, let's not compare the two. Let's just talk about this case and where Article 21 is concerned, where his presumption of innocence comes into question, where prolonged incarceration without trial, without the framing of charges comes into question.
Right.
Does it somewhere down the line challenge what is the principle of criminal law, which is the presumption of innocence?
Well, if you let me complete my point,
Ahead,
I just wanted to, I'm doing it for the benefit of the viewers, as you would appreciate, so that they understand the distinction between what one is on parole, where he's a convict. I do not agree with so many paroles and furloughs granted to him any which ways. But as far as coming to this case is concerned, Preeti, the point is that there is Article 21, but 43D5 of the UAPA is very clear that if there is a prima facie case, and the prosecutorial evidence suggested that there was a prima facie case, so obviously the bail cannot be granted. Bail is the rule and jail is the exception. But as far as the UAPA is concerned, which is a draconian law, which is a draconian legislation, and precisely why we need to have such legislations, because when you try to divide the country, when you try to attack the sovereignty and the unity of this country, when you try to do rasta roko, when you try to see to it that the essentials are not being given or should not be given, when you try to create some sort of a disharmony between religions and all of those things, and if there is evidence pointing to that fact, then there is definitely a case that is made out before the court of the land, and the Supreme Court clearly pointed out that, yes, these two have to be treated. Yes, and one of the points that you raised was a very valid point, Preeti, that if they are collectively tried, then how is it that the punishment is different? But obviously the criminal intention, and let me put a very simple example for the benefit of your viewers. Say, for example, if I hide a criminal, potential murderer in my house, and I tell him that you wait here for an hour and you'll have your victim in the next 1 hour coming in the opposite building. And I hide him, he actually goes out after an hour and he murders. So I become an accessory before the fact. So my criminal intention is only to the extent of shielding. But the one who actually committed the murder, so the gravity of the offense is more.
Okay. No, fair point. You're saying the gravity is more, but it needs to be still proven in the court of law because they've been charged under a draconian, which you yourself accept, law like the UAPA. Right now, even the investigation is not complete. The witnesses haven't been examined, and there is no framing of charges yet. I want to bring in Aman Lekhi and Dushyant Dave into this conversation, but Aman Lekhi, quickly, what's your purview of the judgment today, sir?
Well, I heard Mr. Raju and whatever I read of the judgment. I don't agree with the judgment. I don't in any way share Umar Khalid's political point of view. My issue here is with regard to the process which I'm going to comment, and the framing by the Supreme Court of this particular order, because that is where I think the error comes in. One, I feel that the court has deferred more than what is necessary to the prosecution. Two, I think the court, to the extent it has used terms that delays cannot be trumped, is overstating a principle without defining its content, which have consequences in bail jurisprudence beyond this particular case. And three, the animating premise of this particular section, which is mechanically and ritually cited to deny bail, is missed altogether, and a constitutional court is duty-bound to examine that particular animating premise. I do not know whether that point was argued at all or not. But the animating premise, when you talk about prima facie, the animating premise will take into account not just necessity, which Mr. Raju said, but proportionality and temporality. And these aspects have been ignored altogether by this particular judgment. Without going into the legality of it, I want to flag one point Mr. Raju said. And just to clarify, you are saying that witnesses have to be examined for charge. Witnesses don't have to be examined for charge. Witnesses are examined when the charge sheet is filed. The charge is framed by the court. There is no investigation which is to be done after the charge sheet is filed. But that's it. That's not very relevant. What Mr. Raju said was this is delay. Now, admittedly, there's a high court order for the delay. Now, this is again where the framing comes in. What stopped the Supreme Court to pass a simple order that as far as the petitioners are concerned, they are not entitled to bail, because of the persistent conduct of delay. Now, the Supreme Court does not say that. The very people whom Mr. Raju is saying is responsible for delay, wrong, as far as the process is concerned, which disentitles them for bail. I've been given the liberty to renew this 1 year from now, notwithstanding the fact that the star witnesses have not been examined. That means in 1 year from now, what Mr. Raju said, that this is going to be incentive for them, that they will not delay. But this is not what the Supreme Court is saying. This Mr. Raju is reading of what the Supreme Court has said, again the framing which is wrong. That means notwithstanding the conduct continuing, hereafter, what has happened till now, even if the witnesses are not examined, then they're entitled to bail. Now, my simple question is, if they're entitled to bail 1 year from now, notwithstanding the fact that the star witnesses have not been examined, what stops the court from granting the bail today? Now, this doesn't make sense to me. And that is why this entire framing of this particular order, in my opinion, is something which ignores that as far as the process is concerned, the process becomes punitive. And when the process becomes punitive, the person, as far as I have no sympathy, if the allegation against them is correct, no sympathy at all. It's a very serious allegation. But then, by reason of an order like this, you discredit the process and in some way make a martyr of the accused. So that is a system which in fact works to the disadvantage of the country whose interest Mr. Raju is invoking, because the person who should be punished, what should be the outcome of an offense? The outcome of an offense is punishment. Punish the person for what is done on proven guilt.
Okay.
And not speculate about the guilt and discuss upon issues extraneous to the matter. And that is where I think we have utterly failed. And it's a spectacle which is unbecoming of the mature legal system that we have.
Okay, I want to bring in Swapnil Kothari because he seemed to be shaking his head vociferously and not agreeing with what you're saying. Mr. Kothari, go ahead, make your argument, sir.
On a couple of points, I do agree with Ms. Lekhi, but, as far as the entire process being punitive is concerned, I beg to differ, because there is a certain law that has been laid down. It is a legislation. UAPA is a draconian legislation. The presumption of innocence gets obliterated to a certain extent as far as, it's equivalent to the income tax law, or where I have to show that I have not evaded income tax, howsoever absurd it may be found if I draw that comparison. But as far as the point is concerned that the Supreme Court erred in following this process, the delay is there. The delay was at the instance of the people. And as Mr. Raju pointed out, that more often than not, we are the advocates who push for delays and who push for adjournments, because we believe that if we were to argue this case at this point in time, perhaps it would not yield the favorable result. Now, 1 year from now, I do not know what is going to happen, but obviously the speedy trial has been recommended. If the trial goes through, then we'll have some judgment, hopefully soon, at some point in time. Now, if they were to apply for a bail a year hence, I don't know whether they'll get bail or not. But Preeti, one of the things that I want to point out for the benefit of the viewers, that when serious charges are levied against an individual of this nature, or 2 individuals or 7 individuals of this nature, and if a certain culpability to a certain extent is shown as a prima facie case, then it is a little risky to let the person off on bail. However stringent the bail conditions may be, he could tamper with the witness, he could escape the country. A lot of things could happen. You've had people who've gone to and then obviously, you have the Fugitive Offenders Act. That doesn't come into the picture when it comes to this kind of a criminal legislation. So that is where the Supreme Court must have thought that as far as these 2 individuals are concerned, and if there is a lengthy judgment, normally if you would notice at 10:30, if you start the judgment's reading with a couple of relevant paragraphs is out in 5-10 minutes and we know the judgment. But the court went on and on for about 35 to 40 minutes because it realized the gravity of the situation. It realized that it has to come forth before the public and say these things. So that is where I believe that this judgment, all said and done, is an appropriate one. We can argue on many things till the cows come home, but as far as, the common man needs to understand that justice is not only done, but it is seen to be being done.
All right. But Mr. Kothari, it's been 5 years and the cows still haven't come home. So that in itself is a blot in the judiciary that the trial hasn't begun. But all right. Okay, I want to... Mr. Lekhi wants to come in. Go ahead, Mr. Lekhi.
I just want, you see, that's the 2 issues which Mr. Kothari missed is one, he has not responded to the fact what is the animating premise, and I had dealt with not just necessity, which he's constantly emphasizing, but proportionality and temporality. You're dealing with temporality, and proportionality comes in too, which the Supreme Court has not touched. 2, notwithstanding the fact that this particular provision is, as he says, draconian. Because it is draconian and we are before a court, which in the overarching reality of Article 21, the interpretation has to be in some way consistent with the constitutional sentiment. because the constitutional sentiment overrides the statutory enactment and in some way animates it. And this particular synthesis is absent altogether in this particular thing. And that's one thing which Mr. Kothari mentioned was that as far as the provision is concerned, you have to say, okay, if it is made out. Now, when it is made out, what is important is what the prosecution says is provisional, it's not determinative. And the mistake the court has made is by treating it as conclusive. Because when it says this, I'm not saying it's guilty, but I think there's a prima facie case, in any case, that this is structurally wrong. That's why I'm saying the problem with this judgment is not we may debate whatever we are. Actually, the problem with the judgment is the framing. And the framing of the judgment is going to cause, because in matters of moment like these judgments have to be decisive to settle the law for the future, because that is integral to a rule of law process which brings in predictability. So precision is important. And I find doctrinally, this is an imprecise judgment, because doctrinally it's imprecise, because insofar as the terms are concerned, the terms have not been elaborated the way they should, with the fine distinction that they require, particularly the impact it has made on something as sacrosanct as liberty. My objection, let me repeat again. As I said, I'm not a votary of what Umar, Khalid or the other, or Sharjeel, Imam do. In fact,
so
I
we
condemn
understand
that.
you don't have to draw that distinction. Fine, we got that point in the word
yes,
go.
but the point is, why I'm emphasizing that? Notwithstanding that, because this is what, notwithstanding that, what is more important is the process. Because there can be a wrong accusation tomorrow. And if the wrong accusation is grave, you will not look at the accusation to deny bail, you will apply the process to consider it. And we have to look at the process, and this is where I personally think there is a problem.
Okay, all right. Let's take final comments. Go ahead. Mr. Kothari, make your quick point, and we'll take a quick point from Mr. Lekhi. Go ahead.
Article 21, no person shall be deprived of life or liberty except by a due procedure established by law. Mr. Lekhi knows that, and he must have argued a million number of cases. He is saying that there is a constitutional morality that he's pointing at, and the Article 21 seems to have been effaced a little bit because of the way this whole process has been considered. And he's not, obviously he's saying that bail possibly should not have been granted, but the reasoning should have been different from what I understand from the way he's, emphasizing on this point. Preeti, my short point is that Article 21 was considered, the procedure was there. There is a procedure established by law, which is UAPA Act. What Mr. Lekhi is suggesting in the grand scheme of things on a different day, maybe over a cup of tea, I may agree with him. And I may say that, the UAPA needs to be changed. Then remove 43D5 totally. Remove the words for prima facie at all from that consideration. Then I'm absolutely on par with the fact that, yes, this judgment is flawed. But as long as the Supreme Court, and Mr. Lekhi will agree with that, and possibly any other lawyer would agree that the job of the court is to give a purposive interpretation, as is to interpret the law and not to refashion the law as per its own whims and fancies. So even if it's the Supreme Court, if it's Article 141 binding on the law as the law of the land, you need to follow the law. If the law says X, Y, and you may or may not agree with it on a different day.
All right, I want to get in Mr. Lekhi for a quick point. I just want to give equal time to the both of you, and then we're going to quickly get into a break. Go ahead, Mr. Lekhi.
No, nothing. As far as I'm concerned, I made my point. I mean, my problem with the framing of the judgment, because the framing is wrong, I don't trust the outcome. And as far as the outcome is concerned, I personally feel the outcome should have actually been different had it been properly framed. And at least where all of us are concerned, but I've got to get an idea as to what is it that we have to actually apply in the future cases. And this is this dubious nature, which in some way is the most deleterious part of this particular order. I personally feel there's more of sentiment over here than a reasoning, and we are being influenced more by the gravity than by the principle on which we have to decide criminal matters.
I appreciate both of you for joining us. Thank you for giving us your point of view.